So before the arbitration, what I mean here is before you have a tribunal, before the arbitration actually begins. So you have a lot of issues going on before the tribunal is constituted. One, of course, is constitution of the tribunal itself. Sometimes parties will want the court to actually choose the arbitrators, particularly if the parties cannot agree. This happens quite often, and also particularly in what we call ad hoc arbitration, not institutional arbitration, which we'll look at later on. Another very important role for the courts before the arbitration begins is they might be called upon to analyze and determine the validity of the arbitration agreement.
If you are the claimant, then it is your responsibility to prove your case. You only have what documents you have. You do not generally have the right to ask from the other side to provide the documents in their possession. However, as I understand, in common law countries, the parties have very wide rights to ask the other side to provide documents, and this procedure is called the discovery. So I think the rationale between the practice in common law and civil law countries are different. So in civil law countries, so if this is a card playing game, then you have everything in your hand. The other side does not know what you have. And so each side can prove their cases by their evidence. But in the common law world, so you have to open all your cards. So everyone play with a view as to what the other side have.
Article 17J provides a court shall have the same power of issuing an interim measure for arbitration proceedings seated in and outside its territory as it has in relation to court proceedings. It also states the court shall exercise such power in accordance with its own procedures in consideration of the specific features of international arbitration. I have mentioned the test and outcome of an application of interim relief may be different depending on whether it is heard by an arbitrator or the court. Courts will apply their own procedure to applications for interim relief. This is recognized in Article 17J, which, as I've mentioned, provides that a court shall exercise such power in accordance with its own procedures, although it does also add in consideration of the specific features of international arbitration. I have already made the point that arbitral tribunals should not be bound by court procedure and should have the latitude to apply other, less parochial and more transnational standards to the determination of interim relief.